Are felons permitted to live in a house where firearms are lawfully owned and possessed? Dan McDermott here, McDermott Law Group, not your typical attorneys, guys. Section 922G of the Federal Code prohibits felons from owning and or possessing firearms. Just about all states in this country have enacted similar laws. There are very, very, very few exceptions. This is being challenged right now on a federal level and a state level in all of our courts. Many people are arguing that nonviolent felons should in fact be permitted to own and possess firearms. Some people are arguing that any felon should be permitted to own and possess firearms, assuming that all of these individuals have in fact successfully carried out their sentences. That said, that's not the issue here, and that's not the question being asked. Can a felon live in a home where firearms are owned and possessed? And the answer is yes, but you have to understand this. Since felons are not permitted to possess a firearm, this means they're not permitted to have a firearm on their person or to be in control or have access to an area where they can in fact gain control over a firearm. That is in fact considered constructive possession. Since they cannot have physical or constructive possession of a firearm, the only way in which this is entitled, in which a felon is in fact entitled to live in a house where there are firearms lawfully owned and possessed as a general rule, is if those firearms are kept in a safe and this particular individual does not have access to that safe, does not know the combination of that safe, is not able to exercise control over the firearms within that safe. Hopefully this is helpful. Talk to you soon.